Hello and welcome. My name is Brian Chase. I am Director of Digital Forensics at Archer Hall, and today we're going to be talking about the admissibility of digital evidence at trial. Before I get into our topic, I want to give you a little background on who we are here at Archer Hall, who I am, and why I'm even qualified to tell you about the admissibility of digital evidence. So Archer Hall is a digital forensics company. That means we collect data from digital sources, things like cell phones, computers, tablets, email accounts, social media accounts, electronic medical records. We collect that data, we analyze it, and we testify about it at trial. My personal background, I'm a licensed attorney in the state of Arizona. I practiced law for about 10 years doing plaintiff personal injury work and criminal defense. I've been doing digital forensics work for about 8 years. I have tried cases as an attorney. I have testified about 20 times as an expert witness, and I teach at the University of Arizona Law School. I actually teach a trial skills course there at the law school. So this topic today of admissibility of digital evidence really combines all aspects of my background, that legal background, the trial background, and the digital forensics experience that I have. So we're going to start today by going over the federal rules of evidence that generally apply when we're talking about digital evidence. From there, we're going to talk about some cases where courts have ruled on the admissibility of digital evidence. I'm going to kind of talk about them fact by fact, introduce the case, and then we'll go over the court's reasoning in their ruling. This is based on the federal rules of evidence, so if you are practicing in a state court, make sure you check for your state court equivalents or state court case law. Additionally, almost all of the cases we're going to discuss today are criminal cases. That's just because more criminal cases go up on appeal than civil cases. That being said, the rules of evidence apply equally to criminal cases and civil cases. So just because something is a criminal case doesn't mean it's not going to impact the admissibility of the digital evidence in your civil case. So let's get started here. We're going to start with Rule 901. Rule 901 is the authentication or identifying evidence. So the rule says, in general, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. So what does that mean? Well, we've got a case here. I've picked one. There are many cases that explain Rule 901. The case I picked here is United States versus Videc. It's 553 F3D 344. It's a 2009 decision from the Fourth Circuit. The court says the burden to authenticate under Rule 901 is not high. Only a prima facie showing is required. And a district court's role is to serve as gatekeeper in assessing whether the proponent has offered a satisfactory foundation from which the jury could reasonably find that the evidence is authentic. That's the key wording right there. A jury could reasonably find the evidence is authentic. You don't have to prove beyond a reasonable doubt. You don't have to prove by clear and convincing evidence. You don't even have to prove it's more likely than not. You have to offer enough facts that a jury could reasonably conclude that the evidence is authentic. From Rule 901, we go into Rule 902. Rule 902 is evidence that is self-authenticating. You've probably dealt with Rules 902, 11, and 12 before. That's our self-authenticating business records or records of a regularly conducted activity. That's where you send out your subpoena along with a declaration for the custodian to fill out. That custodian from the business sign saying, yeah, I'm the custodian of records. These records are kept in the normal course of business. You give notice to the other side, you disclose that declaration, and now those business records are self-authenticating at trial. You do not need to have live testimony to authenticate it at trial. There is an equivalent for digital evidence under the federal rules. Those are Rules 902, 13, and 14. Rule 902.13 are certified records generated by an electronic process or system, very similar to Rule 902.11 and 12. If you have a qualified person write a declaration stating these records were generated by an electronic process or system, then it is self-authenticating at trial, as long as you follow the requirements, the notice requirements of Rule 902.11.